Hello and welcome. We're going to be talking tonight and next week about the Constitution and our Supreme Court. This mini-series was prompted by Justice Scalia's death to think we need to learn more about the Constitution in relationship to the Supreme Court. And with me tonight are two people who are really both experts in constitutional law. So I'm delighted they could be with me. My first guest is Heidi Kitrosser, and Heidi is professor at the U in the law school. You graduated from the Yale School of Law. You've been here since 2005 or 2006?
2005, yes.
2005.
Yes. I started as a visiting professor at the law school, and then I stayed on.
Yes. She's someone who did her clerking at the U.S. Court of Appeals at the District of Columbia Court. And as I was learning more about the court system, I read that this is probably the second most important court in our country. So what a nice coup to have that place to clerk. You've written a book, and we're going to talk more about her book later on. I'll give you the title, though, right now. It's a book with the title, Reclaiming Accountability, Transparency, Executive Power, and the U.S. Constitution. And it just came out in 2015?
2015, yes, just about a year ago.
Yeah, so very pertinent to our topic tonight. My second guest is Jill Hasday. Jill is a professor of law also at the University of Minnesota Law School. You also went to law school at Yale. You two have a very similar background. You've been at the U since 2005, so 1 year ahead of Heidi. You are also an author, and the book that, well, you're writing a book right now, I understand, but the book that I read about that you authored, Family Law Reimagined. So interesting topic. Be a topic sometime for a future show, perhaps. You also were clerking at the U.S. Court of Appeals. So did you two know each other back in
Not really. We didn't clerk on that court at the same time. We were in law school at the same time. Jill was 1 year behind me, so I was a third year when she was a second year, and I think we recognized each other in the hallways, but didn't really get to know each other until we got here.
Exactly, yeah.
Okay. Well, I want to jump right in and start talking about the vacancy and about what the Constitution says. And as I read, it doesn't say much about how vacancies in the Supreme Court are handled. Were you surprised when you learned that long ago?
Well, no, because there's a famous line from a well-known, very early case called McCulloch v. Maryland, where Justice Marshall famously said, "It is a constitution we are expounding," and his point was that a constitution, unlike a detailed legal code, doesn't lay out every little detail as to how every contingency that might arise is going to be dealt with. Rather, it sort of lays out broad principles and some rules to sort of set up the basic structure of government. So that the fact that we don't have a whole lot of detail, but we do have some basic organizing rules, is not terribly unusual or surprising.
Your comment on that, would you agree that you're not surprised?
Right. I mean, you also have to keep in mind that when the founders are writing and debating the Constitution, it's very hard to anticipate all the debates that would take place. Almost every aspect of the current dispute over how to fill the vacant spot created by Scalia's death, the founders would be surprised to learn about.
Yes.
So
it's really a freeing thing that they're not setting down. The founders didn't set down more precise guidelines.
Right, because the Constitution is always this combination of sort of the dead hand of the past, but not letting it control too much, because why would you think someone over 200 years ago knows exactly what to do in a modern dispute?
Right.
It is interesting, though, because some of the modern debates about constitutional interpretation really center exactly on that premise. Whether the founders intended.
What was the intent?
Exactly. What was the intent? But also whether they intended to leave us something more like a legal code, or whether we should read its clauses broadly. So some argue from originalist perspectives, though not everyone who calls himself an originalist takes this view, that if we look really hard at the history, we can usually find the answers to every question. Right?
We can divine what they meant.
Right.
Isn't that an old phrase? Well, what exactly does it say about vacancies?
Basically, that the president shall appoint and the Senate will offer advice and consent. That's it.
And nothing about when.
No timing, and really no further guidance. Just that president nominates and it goes to the Senate for advice and consent.
So that's kind of where we are right now, isn't it, as a country? I should mention we're taping on March 28th, 2016. And I mention that because things could change fast in the next months.
A lot could happen by the time it airs.
A law professor that I was reading said, in the end, public politics has an awful lot to do with how this whole process plays out. And that was intriguing to me. I thought, would you agree with that the kind of will of the populace has that kind of power?
Yeah, I think that there are many questions about the Constitution that don't end up getting decided with a decisive opinion from a court. Oftentimes either because the Constitution gives us minimal guidance along the lines that we were just talking about, or because something involves a political dispute between different political branches that's not the type of standard dispute that a court will resolve. Oftentimes the resolution ends up being an uneasy mix of people like us arguing and debating about what the text means, maybe what light history can shed on things, and all of that very much underscored by politics as well. So in this case, there are many things going on. There are debates about what does the text say, there are debates about what has happened historically, and what light does that shed on this. And there are absolutely raw political factors, right? There's the party divide between Congress and the White House, et cetera.
And it certainly is a more divided time right now in terms of politics than we've seen for quite a while.
Although,
would you disagree?
You don't want to underestimate the ferocity of past political disputes. I mean, in the lead up to the Civil War, people are being caned on the floor.
That's true, going way back.
Historically speaking, it actually might not be that bad.
Yeah.
I also want to say that politics isn't necessarily a bad thing. Politics is how democracy works out problems. So the idea that it's ultimately going to be resolved with politics, I don't have a problem with that. The debate is about what does that mean? What are good arguments and what are bad ones?
Mm-hmm. Right now, we seem to have politically a pretty 50-50 split between liberals and conservatives in the court with Justice Scalia's death. Is that your sense of it too?
I think it's very much the conventional wisdom, right, is that we have now with Justice Scalia's death, the 4-4 split between the liberals and the conservatives. I think that's pretty fair. I mean, it's somewhat of an oversimplification. It certainly doesn't hold true for every single type of case. But yeah, people who look at the decisions of the last several years can see there is a split in some of the high-profile, more politically tinged cases that tends to break down along what you might call partisan lines. So I think that's fair, if a bit oversimplified.
The other thing I would add, though, is who gets defined as a liberal versus conservative can be culturally contingent. So from one perspective, everyone on the everyone on the court, I think, is basically is a moderate to conservative. There's from the perspective of an earlier era, like 1968, there's no one you would really say is a hard liberal. So it's the spectrum as we see it. Yes, there's a left side and there's a right side. But I think it's fair to say that the whole spectrum over time on the court has moved a bit to the right.
I do agree with that. I think that's a very fair point. Relative to one another, you can roughly divide them along, again, these classic partisan lines that we talk about. But absolutely, I think the court in many ways, and one could point to many examples, has shifted at least somewhat rightward from certainly the 60s, the early 70s.
Justice Kennedy seems to be the one who has the pressure in terms of, in the last years, being the swing swing person, and I was just thinking personally about what that would feel like to have that kind of pressure in terms of a lot of our cases in the last several years, as you say, some of the political cases were 5-4, and that just feels like a huge responsibility that would make it hard to sleep.
It's interesting you say that, because I think most analyses assume that he's delighted to be the swing vote, because his views get to shape so much of the law.
Well, right. That's
so, for
true.
instance, in recent years, he's been very receptive to gay rights arguments, but much less receptive to to arguments about women's rights and racial justice, and that's what the Supreme Court has done. So, I think most people think it's a coup to be in the middle, because it's exactly what you want tends to happen in these hot button cases.
Well, if you're a lawyer, and this is, yes, I can understand that's a very good point. I did read that I believe every justice we've ever had has been a lawyer.
I believe that's true. I
was surprised that there weren't just a few, outliers.
Yeah, I mean, being a lawyer obviously used to mean something very different in terms of how one became a lawyer early in the nation's history. But I do believe that's true, that in one form or another, they were lawyers by trade or by apprenticeship, by training, et cetera. Where there has been much more variability is in background beyond the mere fact of being a lawyer. So, one point that is occasionally made when we talk about diversity of experience on the court is how relatively similar the backgrounds of the current justices are now, and that used to not be the case. So, for example, in the past, there were many former politicians on the court over the years, something that we don't have now. It's been a very long time since there's been someone on the court with military experience. Just today I was reading, it's been, I think, 25 years since a former criminal defense attorney was on the court. So that's one thing I think that has changed, is that homogeneity.
I did read that most of the people on the court have been Yale or Harvard trained, and that was interesting.
That's in recent years. And I don't think it's a prerequisite in the sense that I've never heard anyone say, Rehnquist and O'Connor went to Stanford Law School, how could they think that they would be fit for the Supreme Court?
Right.
But it is, to echo Heidi's point, that there's been a narrowing of credentials where coming from an elite legal background and pursuing certain kinds of work, over time, that seems, presidents start to perceive that as the safest choice, where no one's going to dispute the person's fitness, basic credentials.
Right now, of course, March 28th, 2016, we do have a nominee, Merrick Garland. Your sense of whether he will get a vote, I'm reading that he won't. Is that your sense too?
Well, just from reading, I certainly have no special inside information, but from reading the same publications probably you all have been reading, it does seem as though the Senate leadership is pretty intent on standing firm on this, which I can only assume means they've decided that it's politically the most beneficial way for them to go. So
Do you
that's
think
what it looks
this
like.
is detrimental to our country in terms of moving forth with cases, or do you think it's not such a big deal as has been made of it? Jill, your thought on that?
Well, first, just a little caveat on what Heidi said. What I understand is they're thinking they would put him up for a vote if the Democrats win the presidential nomination, because Merrick Garland is a much more moderate figure than a new Democratic president is going to put forward. I think the potential danger of this strategy is what's good for the goose is what's good for the gander, right? I mean, it is the precedent that the whole last year of a presidential term, you can't nominate someone. I think actually in some ways the Supreme Court is misleading because all eyes are on it, so and there's actually you have to have a lot of political stamina to resist the pressure to appoint. One of the real, I think, more hidden consequences is there's also a complete shutdown of appointments at the lower court, at the Court of Appeals level.
And now that I had not read.
As the presidency wanes, there's this idea of, no more, we'll wait to see if we can win in the next election, and that leads to overcrowded dockets, and there's just not the political focus on it because it doesn't have the headline and the easy to understandness of a Supreme Court. There's 9 people and one's missing.
but the backup of cases then gets to be a problem.
Yeah, that's absolutely right. And also in terms of sort of the judicial legacy of the president, right? That arguably, although not staffing the lower courts as much as one's predecessor is not as high profile as making or not making a Supreme Court appointment. Arguably the impact is felt much deeper because there are a whole lot more lower court judges, Court of Appeals judges, district court judges than Supreme Court judges. And a lot of cases never get to the Supreme Court. So there's a lot of impact, even if it's not as high profile on the lower courts.
Yes, for sure. We've been hearing some about a recess appointment. Could one of you just briefly define that and then talk about that possibility a little more?
So the Constitution gives the president the power to make appointments when Congress is not in session. And the idea is those appointments, the person can stay until the end of the subsequent session. The recess appointments clause came from an era when transportation and communication were very slow, and the members of Congress would go home for the summer, and they're not coming back for 3 months. So the founders were worried about, you just can't fill it because by the time Congress gets back in session. My own view is that in the current age, it's a little problematic to rely too much on recess appointments because they're more the president seizing the opportunity to appoint someone than really Congress is not going to come back in time.
Yeah, I think that's right. I mean, there are a lot of ways in which the phenomenon of the recess appointment is very much gamed now by both sides. I mean, on the one hand, Jill's absolutely right that rather than the technological hurdle of Congress not being able to meet today, that oftentimes the reason for a recess appointment may be as much about the fact that there's no other way for the president to get the person through. On the other hand, on Congress's side, there's a fair amount of game playing in terms of doing things like holding pro forma sessions where the Senate Majority Leader will send someone in to bang the gavel once every few days to keep the Senate, technically in session so that it doesn't create a recess opportunity where a recess appointment could occur. But I think in many ways that just bolsters Jill's point that today it's as much about kind of political gamesmanship as about any necessity, in many cases at least, to a point when Congress is unable to meet.
The balance of power, and we only have 5 or 6 minutes left, but a big topic I wanted to run by you. When the framers of the Constitution were putting it together, do you think they were worried that there wasn't going to be a balance, or were they just thinking this makes the most sense? I'm just very curious about what was in their minds, because I mean it's a brilliant scheme, really, isn't it?
They were most worried about the legislative branch.
Were they?
And that's one reason that Congress is divided in two. And the whole thing is really meant to be a balance of what they anticipate would be the supreme power and influence of the legislative branch.
I would have guessed it was the presidential power.
Because you live in modern America.
Right, that's
it
true.
It turns out, and I'll leave it to Heidi because this is one of the topics of her book, where over time, the executive branch has clearly become the most powerful with its control over both the administrative state and the national security apparatus. And that's one of the many things the founders did not anticipate.
Sure.
Yeah, they absolutely were worried about a strong legislative branch, although the history is so interesting because you have the period most immediately prior to the founding and the draft of the framing and ratification of the Constitution, where indeed you had in the post-independence but pre-constitutional period a very strong national legislature that was created and virtually no executive, essentially. The legislature essentially performing executive functions, in part because at the time, immediately post-independence, they were scared of a strong executive. So at the framing period, they were most afraid of a strong legislature. At the same time, immediately prior, just a few years earlier, immediately post-independence, I think they were a little more afraid of a strong executive. And so ultimately what you have in the Constitution is this effort to really balance it so that you don't have one branch that's going to overtake the others.
Do you think today that the judicial branch is as strong as it should be? Is it stronger than it used to be, less strong? How would you rank it?
Well, many people have argued that the judicial branch over time has become much more activist and much more willing to insert its ideological views, including by judges who supposedly decry activism by other people. And personally, I think that's quite plausible. I don't know exactly how to answer how powerful the judiciary should be, because it's also, I think there's a counter-argument, given the strength of the executive, a very strong judiciary is probably a good idea. I don't think it's the power so much as how they exercise it.
The balancing
Right.
again. Mm-hmm. Yeah. What would you say, Heidi?
Yeah, I guess I have a similar set of views, and in particular, I would say, while there probably is no perfect way to say, well, exactly how strong should it be, I'm fairly comfortable with its level of influence at this point, because I think, I don't think it's an overweening tyrant by any means. I think there are cases where absolutely the judiciary effectively gets the final word, but I think there are a lot of cases, such as the question of, how the appointment situation will pan out, where either because cases don't reach the Supreme Court, so there's not one single uniform decision, or because a case really presents a controversy between different political branches, where the court really doesn't have very strong hands. So I tend to feel fairly comfortable with the balance as it is right now.
We have just a couple minutes left before we close. I want to talk just a minute about your book,
Sure.
because it fits in here, as Jill kind of segued to it. Next week, when you see our part 2, we're going to talk about cases that are going to be heard by the Supreme Court, cases that will be revisited. But now I want to just share a little bit about reclaiming accountability. And could we hold or get a zoom in here on the cover? As I said earlier, Heidi wrote this book, and it came out last year, 2015, published by the University of Chicago.
That's right.
Law School. And an interesting cover, which really symbolizes what, Heidi?
Well, it's meant to, I'm not sure how well it comes across, but it's meant to essentially symbolize light coming into darkness, or perhaps darkness overtaking light, depending on how you look at it. And the reason for that is because the book is about presidential power and the Constitution, but in particular, the angle I take is to focus on the president and the executive branch more broadly's ability to keep secrets, so hence the transparency and the light metaphor.
And such a hot topic, really,
Yes.
right now in our country. Well, we'll talk more about the book next week. If you do want to learn more about the book, we're going to put on the screen right now a link to the University of Chicago publishing house, so you can access the book that way. Well, just one last question, and then we need to break. Do you think that the framers of the Constitution would have had life-term appointments for the justices if they had known how long we'd live nowadays? Back when they made that call, I'm sure the life expectancy was under 50.
Although, keep in mind that justices have always been on the high end of the socioeconomic spectrum, so it's always going to be relatively long-lived people. There's also a lot of evidence that being on the Supreme Court is in general great for your longevity, because it's so
Is there
mentally
a
stimulating.
Relatively
correlation?
relaxing, yes.
But I think there's advantages to life tenure, even if it's a long life tenure. It's the total freedom of knowing you never need to get another job. This is it as long as you want it, basically as long as you are interested in working. And
There's no lame duck period.
right, and there's something to be said for that, even if it lasts a very long time. Yeah.
Well, and I think, back to sort of the question of, what would the founders have thought? I mean, of course, the most immediate answer is who knows, right? But sort of extrapolating from what their concerns were, they were very concerned about independence, about judicial independence. And so from that perspective, I tend to think that, even if they considered longer lifespans, they would have ultimately said the best way to ensure independence is life tenure, with the possibility of impeachment in very extreme cases.
Mm-hmm. So you're both saying really life it's a good thing that we have justices.
I think it has some problems. I do. I do think, though, that the judicial independence factor is one mark in its favor. But I do think there are problems.
It's interesting that in some state courts, they have age limits, and the reason is because they don't want to have reviews for is the person senile, is the person. They feel that just strict age limits actually preserves independence in a way that the possibility of review for declining competence might impinge on it.
And that brings up a really important question. We've not had that issue, though, have we, with the Supreme Court in terms of worrying about competency that I've read about?
I don't know that we've ever, to the best of my knowledge offhand, although I haven't looked into the question carefully, I don't know that we've had at least a high-profile situation that's come into the light. I think over the years there are occasionally whispers, perhaps inside the Beltway and elsewhere about, is so-and-so really at the top of their game?
Is she losing it?
Yeah, as far as I know, though, I don't think there's been a really high-profile case.
We don't have a President Reagan type story, do we?
Right, as far as I know, unless you can think of an example.
I mean, there's quiet whispers of someone's being really their clerks are doing all the work and they're just showing up, but no case where it's that open.
Out.
Right, right.
Well, you've answered many of my curious questions. I could go on and on plying you with questions, but thank you so much. They are coming back, as I said. Next week we're going to talk about some of the big cases in our country that are impacted by Justice Scalia's death and just some of the ins and outs of what is coming ahead. So tune in next week, and thank you both so much.
Thank you.
It's been really informative.
Thank you very much.
Thank you.